On Monday, does Kelsey Fitzsimmons take the stand, Michael Bryant?
Ooh, that's a very interesting question. Now that the jury's out of the mix, who knows? But we want to get you ready for that upcoming trial.
Justice, where are you? Michel and Linda are here.
Love you, Linda.
Where is justice? Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and down me, I lead the way. Hoping justice will win the day. Listener clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
But all righty then. Welcome to Friday. Good to have you along. Michael Bryant here. Hello, Linda Baden.
Hi, Michael Bryant. Any plans for the weekend?
You know, I'm wrestling with people have been following my latest DIY project, and I got the tile in, but I still need to grout, which is another day of slopping around on my knees, and then obviously the baseboards and molding needs to go back in. So that would be my exciting day because I cannot do another minute of legal work. I mean, this is a very busy time for me this quarter for the next 3 months.
Right.
And I just need a brain break from that. And then, of course, early next week, I'll be at Kelsey. So how about you?
Yeah.
What's happening?
Yeah, I'm doing the final preparation for my appearance in federal court. Actually started working on it yesterday and today, and here we go. So
all right, then. Okay. So what we thought we would do is, kind of a combination of things. We want to use the hearing from earlier this week, which was the go-go hearing, as I call it, the final pre-trial. The go-go, because that's where the judge says, we're going, or we're not. And they're going without a jury, as it turns out. So we're going to use that, but just as a jumping off point, because we want to cover whatever pops in our brains, what we've been thinking and talking about between us in terms of, wow, now there's no jury. That really changes the complexion of the case in terms of presentation and level of evidence and number of witnesses. I mean, all kinds of changes. So in the context of letting this hearing play out, we'll start, and talk about those different things. Does that sound like a plan?
Sounds like a great plan.
Okay. So what we will fire up here, and this is the raw video, which, means that we'll have some bumps and I will move from those and move forward and past them once I find it. And I've got so many things open on this desk.
And you have to remember, since we keep talking about it's Kelsey Fitzsimmons' case, but she's a defendant, so the prosecution has to go first on Monday. Remember that, everyone.
Yeah, and the prosecutor, Kelsey, made some sort of, I've got my witnesses lined up, and I'm hoping I can adjust them because clearly it would have been, jury selection day. So, he didn't make he wasn't really whining too badly, but he clearly was making the court aware that there might be a hiccup here or there. And I think the court understood that, gets it. I don't know if the court had some prior notice, that this was going to happen. But anyway, we'll see. It does change the complexion of it. So here's a lovely profile shot of Courtney, who is Tim Bradle's paralegal. And while that's how the shot was framed up by the pool camera. So I don't know if he was using it to focus. I don't know, but.
Good morning, Your Honor.
Good morning.
March 18th, 2026, Courtroom 4, Lawrence Superior Court. The Honorable Justice Jeff Karp presiding. Calling the criminal matter of Commonwealth versus Kelsey Fitzsimmons, 2025, 77 CR 311, scheduled today for a trial readiness conference. Could counsel please identify themselves for the record?
Good morning, Your Honor. James Hoover, Associate on behalf of Commonwealth.
Good morning.
Good morning, Your Honor. Marina Moriarty.
Good morning.
Good morning, Your Honor. Brandon on behalf of Council.
Good morning, Your Honor. Martha Cooley on behalf of Kelsey Fitzsimmons.
Good morning. Good morning, Mr. Fitzsimmons.
I'd like to say one thing as they're saying their good mornings. I hope the microphones are better next week.
Well, that's a good question. I've been back and forth with Amanda, Law Girls, Not Attorneys Due Process, because there's, first of all, it's not going to be in this courtroom. They're moving it to courtroom 2. which is supposedly more like the first floor courtroom, which
Right, the big
is,
one.
yeah, which is not this one. Remember, they had the elevator issue and they moved it from this one down to the first floor. So the question became, one of audio. And interestingly, this is probably one of those high profile, recognizable trials that Court TV / Law and Crime, whoever they are now, Jelly Smack, they're not doing it. So they're not doing the normal, when I was there, you were wiring the witness stand, you're wiring both the sides of the defense counsel, and you're wiring the bench. All of that, you're strapping your own little mic to the existing microphones because you can't count on people being on mic all the time.
Right.
That's not happening. And Amanda and I went back and forth about it. We just don't have the capability at this point in the process to do a lot more than what we've done, which is put a wireless or even a wired microphone at one or maybe the witness stand. We haven't figured out for sure what's going to happen because we have limitations. We'll see. It may be, I hope it's better than this. It won't be as good as somebody that's able to mic every key location. So we'll see. We will see. This audio, I don't think, because I did not go to this hearing. So I do not know where they put the microphone, if anywhere. I don't see it anywhere. And that's always my thing. I'm always telling this was Channel 10, I believe. Channel 10. And I think they may be the ones that are there for the trial. And I tell Amanda, we got to get a microphone anywhere in the orbit because you can see all these microphones, right? You see them everywhere.
Right.
And they, in theory, feed a series of small speakers around that room. And I've seen some local cameramen just put their microphone right there by that little speaker, but you're then still depending on what is picked up by the microphones. It's not ideal. But if everybody is good about staying on mic, the witnesses usually are because they're told by the judge many times, right?
Right.
That
Talking to the microphone.
Yes,
Right.
pull it closer, whatever. And so it's usually the attorneys that are the problem because they're wandering around. So we're going to do our best. We'll have some level of audio, and we will bring to you the best that we can. So that was a wrinkle that just occurred this morning. Actually,
Courtney Healy, our paralegal.
Okay, yeah, that's fine.
Thank you so much.
Okay, so we're really on to discuss the juror questionnaire, the draft of the juror questionnaire that I emailed you folks on Friday. I did have some preliminary questions, if you don't mind. I think these are fairly quick.
So, he's asking about the jury questionnaire because Bradel has not dropped the bomb on him yet, but it's coming.
So let me just ask about trial readiness. Are both sides ready to begin impanelment on Monday and then start the trial the morning after we get our 14th juror? Yes. Okay.
Judge, on that point, I don't want to waste a lot of the court's time. So just a suggestion is, could we do the rest of the housekeeping matters, take a quick break, and then put the questionnaire to the end? Because we may not do it. It may be a moot point.
Okay. I actually, that's one, you're ahead of me on my agenda because I was going to, let me just skip to that item, right? What you're speaking about. So what I was going to say, mention to you is that I believe at the last hearing you mentioned, Mr. Bradel, the possibility of Ms. Fitzsimmons waiving her right to a jury trial.
Yes.
And what I was going to say to you, and we'll give you some time, we'll take a break and give you some time to talk about it. But what I was going to mention to you is that I really want to, it appears to me that the law, both the statute and the rule, give me some discretion as to whether I would grant the waiver. And the only reason I would, well, let me just tell you my thinking is I would like to do everything possible to avoid having to bring 70-ish jurors in on Monday if it's going to be a waiver. So what I was going to say to you is I would need a decision by Friday, but it sounds as though maybe you'll want to talk with your client about that even today. So we'll pause.
We were going to have to take like 5 minutes and then.
No, we'll when we get to that point, you'll take as much time as you need. All right, a couple other quick things. So the trial, we're trying to coordinate having the trial be held in courtroom 2 on the 2nd floor, just to accommodate more audience and media members than we can fit in this courtroom because, as an example, the camera that is set up is actually, I think, either in the jury box or just too close for comfort. So our hope is that the trial will occur, whether it's bench or jury, down in the second courtroom number 2. We are still working on some logistics at our end, and you folks, especially the Commonwealth, may have some logistics that you'll need to go over with Mr. Ruane. If the logistics cannot be overcome, then they can't be overcome. But at least that would be my preference, is to have a bigger courtroom than a larger courtroom than is here. All right, so that's that. And also, I will need, if there's going to be a juror questionnaire, I'm still missing Dr. Zeisel's address, which used to be in Brookline. I'm assuming, is he still in Brookline?
That's another development, Judge. We're actually not going to call Dr. Zeidel.
Okay, all right, but so would well, we'll get to it later. I'll also need, when and if we get to it, I need an address for Charles DeChara. Is that Commonwealth's witness or the?
No, it's the defense put him on there, but I'm working on that actually.
You're working on the address?
Yeah.
But it's a defense witness?
It was an independent investigation that was done by the North Andover Police, and they created a report.
Oh.
I wasn't going to call him. He put him on the witness list. But I think I probably have better quote unquote connections to get an address. So.
Yeah, just the town or the name of the business or something sooner than later. All right, so those were the only 2 items that I missed. And by the way, I did take out Miss Fitzsimmons as being listed as a witness. So you're going to actually see in the next version that in order to save me having to renumber, I just put number 20 intentionally omitted.
Okay, we're going to move forward from this, but the important point that was 2 things that were noted. One is there's some independent investigation done by one of the witnesses, and apparently it's a defense witness, but the prosecution had it on their list, and the prosecution said, "I'm able to provide the court the address." Usually they provide addresses for them so they can, follow up, make sure they're going to be there. So that was one thing. The other thing was that, it seemed like Tim Bradle was trying to kind of hold back on the waiver until
right, it did, exactly.
Yeah, until he, was kind of forced to, and then later that morning he kind of caved in on that. So what I think might happen, practically speaking, like during this hearing, the media is in the jury box. Well, obviously during a normal trial with a jury, you ain't going to be there, so you're taking up seats in the gallery.
Right.
And if you're running a camera, then you're kind of squished into a corner in front of the bar, in the well of the court, but as far away from anything as you can be, quite often right next to the jury. And that's why they make sure, when they're panning around,
right.
That's how they catch a juror every now and then.
Except for the Afroman case, didn't they just broadcast the whole jury?
Only during jury selection, but there they were. They were all sitting in the gallery with their ID tags, and the Q&A is going out, and so you go, there's that woman. She's, and you could easily, if you took the time, put together, who made it in the box and who didn't. Anyway, not an issue here. And since there isn't going to be a jury, I think they'll probably allow the media to take those seats, and the camera or cameras to take those seats as well, which is great. That means that if in fact it's a larger courtroom, then there really will be more seating out in the gallery that the media won't be hogging. So, okay, let's see. This is the probation person checking in. I find this interesting. I don't know if you heard about this or not, but remember we talked about the scram?
Right.
And we're like, certainly they're going to take her out of that mix for the days of the trial, because she has to carry that little device with her with the little air tube hanging out of it. And if it randomly goes off, she has, minutes to blow into it.
Don't tell me they're going to keep it on her and let it happen during the trial.
Watch and learn.
Okay.
On the scram device, is that probation?
Yes.
Yes. Hi, how are you? Good. Do you mind just stating your name for the record?
Yes, Your Honor, Probation Officer Tony Kidder.
Okay, and Officer Kidder, everyone, me just think out loud for a moment. I'm concerned, or should I be concerned, that Ms. Fitzsimmons is going to be alerted during the trial to blow into a scram device? Yes.
Yes, Your Honor, I did speak to my supervisor in regards to the scram earlier this morning, and I was going to contact electronic monitoring to make sure that it did not go off during the time that she was in the courthouse.
Okay. All right, I just, I don't know what I don't know. And all I know about the scram device is what the probation officer at the last hearing told me about. So I just want to make sure, I'm sure that you folks are out front of this, but let's just.
What did she say?
She's saying that we're going to try and, I think she basically said disable the audio so that if she's got it, it won't accidentally go off, or if it does, you won't hear it.
But then she violates the screen if she doesn't blow
Yeah.
into it. That's
Well,
so wrong. Why can't they just remove it from her for the trial?
I don't know. And, this is a
Ridiculous.
disaster waiting to happen. You know that something is going to go wrong and it will go off audibly. Now, obviously less important now, there's no jury.
Right.
But still, it's such a ridiculous requirement under the circumstances. Is she going to bolt from the room and have some drinks? I mean, what do they think is going to happen? Okay, and I agree with you. This audio could not be worse. When I heard it live, it was slightly better, but not much.
And that she isn't seen lugging it around or throwing into it in the courthouse. It's still a small courthouse, right? So if probation can do something to shut it off.
Yeah. So basically saying that they have the ability to shut off that audio. Okay, great.
Makes sense.
Yeah, the Commonwealth filed a motion to eliminate on Friday, I believe, or over the weekend, I'm sorry. The Commonwealth filed a motion to eliminate, seeking to admit a number of text messages between the defendant.
Now they're talking about the text messages that we now know are out there.
I'm still stuck on the scram. I'm sorry.
Here, get it out of your system.
Why the judge there can't say, okay, I'm taking that condition off as a condition of bail during the trial date.
Duration of the trial.
Period. That's it. That's all. Then you just get. That's all. I don't get it. I don't get it.
know. I get the feeling sometimes from the last hearing and now from this one that he's tiptoeing around certain issues that relate to McCarthy. Naaman. Remember how he was about removing the requirement that she basically live with mommy?
Right.
And he had to wait and get some help from somebody, special dispensation. He had some conversation with somebody, and then sure enough, he removed that condition. All of these things are connected to the bail condition set by McCarthy. Naaman. So I just get the feeling he's tippy-toeing around that. That's my gut feeling. Otherwise, why would he not do exactly as you say?
Right.
And that is just, can you just put it in the back room? She'll take it home with her. She'll drop it back off in the morning. And, that's it.
So unbelievable.
So that's how that continues. Now they're talking about the text messages, which I'm going to pass because we know the result. For those who don't know, text messages ultimately were a motion in limine brought by the Commonwealth. They wanted to get these in. This is very inflammatory. It's great stuff.
It was great stuff for her. It's great stuff for her.
Now that we've got it, maybe not so great stuff for him. And the judge even said to Bradel, I think this is great for your client. That's before we got them. And so I'm thinking, really? And all he agreed to redact was the one sentence, which we've now seen all of it, in which the alien says Kelsey hit him a number of times. They were going to take that little chunk out. That's it. The alien then goes on to say, we shouldn't be worrying about that now. We should be worrying about being the best parents we can be.
Yeah, he was setting up the call, right?
Yeah, that was very.
We wanted her to admit it, and then she said that's not true, or something like that. So,
and it's like, okay, well, don't worry about that. We need to be the best parents we can be. Okay, all right.
The motion and the exhibit being the text message.
Let's see. I think.
Know who the folks are, but welcome. And you referred to another member of the media?
Yes, this is the law girl there.
Oh, I like this. Watch this. He starts to use an example, right? And he uses the law girls as an example. And I'll see if we pick this up.
I am not on social media or
He's talking about social media and the impacts, right?
Okay.
So don't assume I know who the folks are, but welcome. And you referred to another member of the media?
Yes, yes, this is the law girl, they have their own blog.
No, I'm confused. Why did he do that?
Because Bradel was talking about the impact of social media and how in relation to these texts, and he whether or not they should be impounded. Remember, initially they
Okay.
were impounded.
Right.
Now
initially
they are
were.
no longer impounded, as we know. And so the judge was saying, I don't really know social media. I don't know anybody who's on it or who would. And so he actually pointed out, I think Mass Media, I think. But anyway, and
I love it.
I sent Amanda a note. I said, nice shout outs, because he had, when the judge said, who's that you're talking about again? And he identified them twice. It's funny.
I love
It
it.
just opens the door to.
And judge, get used to it. It's the new brave new world.
Relevant to whether or not she assaulted Noonan in the bedroom, and it was just the two of them. There's no relevance to it, to this charge, and there is prejudice, there is unfair prejudice to show that she's in a fight with her boyfriend. Nobody wants to be judged on that, Proposition A, when Proposition B is completely different, that we're here for trial on. So I just don't see the connection. Her state of mind about Justin is not her state of mind about Noonan. And there's just.
So now Tim's having the conversation we had the other day, when it's a question of state of mind. Well, yeah, clearly, but not as it relates to what she ended up interacting with Noonan about. That was your position. Mine was broader. Mine was more like, I think her state of mind all day leading up to and past that event is an issue. Ultimately, it became moot because first the court struck that line and then unimpounded the text, and they're all
Here we
coming
are.
because the judge is going to be the guy figuring it out. Okay, let's see.
She gets this restraining order full of horrible nightmares. She acts accordingly on it. The government puts their case in, we put our case in, and the fact finder decides.
So, but don't these text messages help your client show that? Because I'm not, again, listen, the Commonwealth, you know your case, both sides. I only know what little I know from the file.
Sure.
But when I read these, yes, maybe there is anger, maybe you could say that, but there's also an absence of any concern for her mental well-being by Mr. A. Allen, any comments made by Ms. Fitzsimmons that would lead one to believe that she was suffering emotionally at this time, which would,
So this is interesting in this context. This is the judge basically telling the parties, Commonwealth, you know your case. I don't, but these things, these texts seem to help the defense more than the Commonwealth. He is saying all of that before he knows he's going to be the fact finder in the case. So he's given us a bit of an advisory opinion about that evidence.
Oh, that's interesting because, right. I mean, when we've read it, we think that helped her tremendously, these texts.
Especially toward the end, it signs it off with, I love you, and I'm going up there for a day, for the night with the kid. Nothing like he had characterized in that affidavit.
Right.
And so now we have the fact finder giving his spin on those texts before he knew he was going to be the fact finder. So that's a huge tip off for the defense that this guy likes these texts for Kelsey. So that all unfolded, kind of organically. Nobody had a big master plan, but that's how it happened.
Yeah, but you know what? Remember, the judge kind of was forcing the issue. I think Tim wanted to hold off making the final decision about him trying the case as a fact finder until this hearing happened the other day, right?
He was actually, he said at first,
we put it to the end
by today, by Friday, the Friday before the trial. That's pretty late because if you have jury coordinators, and they're scrambling people, last thing they want to be doing on Friday afternoon is telling people don't show up, and so this happened on Wednesday, and the court ultimately learned that day. So just practically speaking, the court people had 2 days to tell the prospective jurors to stand down. But in
Plenty
the
of
interim,
plenty of time. If there's a snowstorm in the morning, they always tell prospective jurors to say, then they're automated systems.
you
They
would
can just
think,
automate that.
I
I would
don't take
think.
anything for granted with these folks. You would think.
I'm just concerned about jurors, just knowing, but,
Your Honor, this is, I do not see a good faith reason for the Commonwealth to ask for this to be impounded, given the nature of what is in the public.
So again, he's very concerned about jurors, which becomes moot. So let's get to, I think he takes a break here. Hold on. Yeah. And then I was trying to figure out whose feet are these? they were,
Whose feet?
they were, this was the shot live while the court was on recess. And there was a lot of tapping of the feet. And so I couldn't quite piece them together. So just me with some free time. Okay, so then they come back, and ultimately, what are they going to do? They're going to have a little colloquy with Kelsey Fitzsimmons, right?
Right.
Because you can't just say, "Hey, my client's waiving a right to jury trial," and then okay, great, put it on the record. This was Gubatosi. Let me see if we can.
You didn't sneeze properly.
I did not. Gubatosi. When Bradel said we're going to waive that, he immediately trying to create a conflict with this judge. That Bradel and this judge had some pre-existing history, and they do. And the judge went into it in great detail. But Gubatosi was trying to, get him off.
Oh, dirty Commonwealth.
And Attorney Bradel told them and the world, I guess, that he worked together in the DA's office some time ago. And so I think there's a perception out there, but whatever it is, that the defendant had put out there. Like I said, I have no reservations as is your ability to be fair and impartial, but I think I needed to create a record about that.
no, that's a very good point. So, I don't, let me say this, I said before when I was joking with our media representatives, I don't pay attention to social media. I'm not on social media purposely. I don't read or listen to or watch or whatever media accounts of what happens in cases that I preside over or that I potentially could be involved in. So I know nothing about that, but I think it does make sense for me to say a couple things related to that because it strikes me that I did discuss those things with you folks, but I did it at sidebar. All right, so I'll just state for the record that Mr. Bradel and I, so we worked together, well, Mr. Bradel and I were in the same starting class of new assistant DAs in January of '95. Mr. Bradel, I have a picture of all of us, including Mr. Hagan, Judge Hagan, who like me back then had a lot more here. So Mr. Bradel and I were in that class, starting class together. My memory is that I was assigned ultimately after the class. I think we met for a couple of weeks. We were a training class. I was then assigned to Roxbury District Court and Mr. Bradel to Dorchester District Court. And so that was '95. I left the DA's office in 2001, and at that time I was the chief of the domestic violence unit, which was a superior court unit. So, Mr. Bradel, you can correct me. I don't think that we ever worked together in the sense of worked in the same courthouse, worked on the same trial team. I'm not sure that you and I ever even had a beer together back then.
I agree, Judge. I don't recall one, and I think that I put you kind of in the same boat as Judge Deacon down in Middlesex, where we always had a respectful cordiality at work, but nothing past that.
All right, so back 30 years ago, they worked at the DA's office together, and ships passing in the night. And one of the funniest parts was, and I've heard this twice, two different hearings, when Judge Karp first came on the bench in this matter, he was really just loosely talking to the attorneys about his connection to them, to make sure there was no conflict, whether he was going to be trying the case from the bench or not. And twice now, both this day and then, Gubitosi reminded the judge that they had 2 cases that he'd tried in front of him. And the judge never remembered either time. And so it put Gubitosi in that weird, well, I guess I'm not very memorable, position, because the judge had no clue who the guy was, even though he'd tried cases in front of him. That's not good. So anyway, so no conflict. That's not going to pan out. That's not going to work. So let's take our little breaky, and then we're going to hear from Kelsey Fitzsimmons. Let's see. There we go. And she's speaking into the microphone, I believe. So we'll see if that's helpful.
Yeah, she's seated at the table, right?
It just depends on where they place the mic. I was not there to orchestrate the mic placement. So
why don't you folks, why doesn't she take the witness stand? And we can pull a chair over for you, Ms. Attorney Coakley, if you'd like. I can stand.
And then we'll each give our 2 reasons we do or don't like a bench trial versus a jury trial.
And generically, right?
Yeah, just generically, not relating to this guy or anything else.
Please. Ms. Fitzsimmons, could you raise your right hand? Do you solemnly swear to make true answers to such questions put by the court or responding to directions to help you God?
Okay. Good afternoon. You can have a seat.
Good afternoon, Your Honor.
You can put yourself right up to that mic. So as you know, I'm Jeff Karp, and I'm a judge here at the Superior Court. And I understand that you'd like to give up your right to have a jury decide whether you're guilty or not guilty of the charge. I need to just ask you some questions to make sure that you understand the right that you're giving up and that you're doing it voluntarily, okay? And that you know what the consequences are.
And for people who don't know, that's Martha Coakley standing next to her.
If at any time you don't understand something that I say to you, it's perfectly fine to interrupt me and tell me I don't understand. If at any time you'd like to take a break and speak with Attorney Coakley, we can give you that opportunity. We're in no rush here. It's very important that you understand all that I tell you. Yeah, okay? All right, so first thing I'd like to do is,
Michael, could you pause it 1 second? Because I think this is, you start with the first thing. I do want to announce, as I promised, as you see in our feed, after this show ends, there is going to be a fundraiser that we said we would promote, and we're doing that in the scroll that you're seeing below at 7 p.m. It's being hosted by Common Sense Investigator. We have put the YouTube link to her channel there with Maz Media, Emily C. and Broken Baker, and I think other people also. But just so that you're not seeing an AI hallucination in our feed, that there's a reason for it. So yes. I thought this was a good time to break and mention that.
Yeah, good idea. And hopefully the money will continue to flow in. I know there have been a number of fundraisers collecting money to help Kelsey cover all these costs.
So you understand that you're charged in a single indictment with the crime of assault by means of a dangerous weapon. Do you understand that?
Yes, Your Honor.
Okay. And do you understand that have you discussed with your attorneys what the Commonwealth needs to prove at the trial for that charge?
Yes, Your Honor.
Okay. And do you feel as though you understand what they've told you about that?
Yes, Your Honor.
And do you understand that that charge, assault by means of a dangerous weapon, carries up to 5 years in state prison if you're convicted?
Yes.
Okay. Attorney Coakley, either you or Attorney Bradel have gone over the elements of the charge with Ms. Fitzsimmons?
Yes, Your Honor, we have.
Okay. All right, so I need to just ask you some background questions to get some background information. Some of this I already know, but I still need to, I need to ask you formally. So if you could state your full name.
Kelsey Erin Fitzsimmons.
And how old are you?
I'm 29.
What is just your month and year of birth.
11/18, November 18th.
And where were you born?
Concord, Mass.
How far did you go in school?
I got my bachelor's degree and I went to half of law school.
Okay. You went to what?
Half. I got
Half of law school? That's enough. Was that enough for you?
No, I'm gonna go back.
You're thinking about going back?
Yeah.
And you said you got a bachelor's degree in what?
In criminal justice.
Criminal justice, and where from?
Where am I from?
No, where did you get the
I'm
bachelor's
sorry.
degree
I'm
from?
nervous, I'm sorry. Fisher College in Boston.
Okay, all right, and totally understandable that you're nervous. All right, and
So she has a master's and a doctorate degree.
And she went to, she said 2 years of law school.
Right. So
she says she's going to go back.
That's right. I
once
imagine
all
that
the
right
dust
now.
settles, you know.
I imagine she would like to go back and be a lawyer after all this. She probably could try a case right off the bat.
Yeah. Yep.
You can't be presently working, right? You're not working now.
No, you're not.
All right. And your last job was with?
Patrol officer with the North Andover Police Department.
Okay, and how long were you there, roughly?
About a year and a half, if you count the academy.
Okay, so you went to the police academy, and
Yes.
then, okay, what else? And just normal job duties as a patrol officer in North Andover?
Respond to 911 calls, emergencies, medical emergencies, calls for service in the town.
Okay, all right. And did you take any prescription medications, over-the-counter medications, or drugs in the last 24 hours?
Yes, I have.
Okay, and what have you taken in the last 24 hours?
In the last 24 hours, I've taken fluoxetine,
Okay,
hydroxyzine,
okay,
and lorazepam.
all right. And do any of those medications, or have any of those medications affected your ability to understand the proceedings today here?
No, Your Honor.
All right. Did you consume any alcohol in the last 24 hours?
No, Your Honor.
And have you ever been treated for any mental health condition?
Yeah.
Okay. Do you feel as though that you're suffering from any mental health condition today? In other words, that like right now as we're going through this, that you're feeling some effect of any mental health condition?
No.
And do you feel as though your mind is clear today?
Yes, Your Honor.
And have you understood all that I've discussed in open court with the attorneys about, up to this point, about even like the motion to admit the text messages? Have you understood all of that?
Yes, Your Honor.
Okay.
Just real quick on the meds. I think the first two are blood thinner type, for the injury she suffered, and then obviously lorazepam, which is basically Ativan/Valium. It's a CNS depressant, central nervous system depressant, which is a painkiller, and some would suggest a mood elevator. Although she mentioned, to me, that'd be the one most interesting to pursue, but she seems pretty clear-headed. It's not like I'm hearing or seeing anything that would make me wonder if she is intelligently, knowingly, and voluntarily waiving her right to a jury.
No doubt about that. This is voluntary, in my opinion, listening to her.
So I'm just going to go over your constitutional rights. So you have a constitutional right to one trial of the charge. And you have the right to choose whether to have a trial before a jury or a judge. At a jury trial, the jury decides whether you are guilty or not guilty of the charge. And the judge's job during a jury trial is to rule on legal issues that arise during the trial, to instruct the jury on the law of the case, in other words, what the Commonwealth has to prove, and to impose a sentence if the jury were to find you guilty. So that would be the judge's job during a jury trial. But the jury would decide whether or not the Commonwealth proved that you were or are guilty beyond a reasonable doubt. All right, you understand that?
Yes, Your Honor.
And at a jury trial, you have the right to a trial here with 12 jurors. These are people selected from the community. You'd have the right to participate in selecting the jurors, and you could not be found guilty at the jury trial unless the Commonwealth convinces all 12 of those jurors that you are guilty beyond a reasonable doubt. So do you understand all of your rights and how a jury trial works?
Yes, Your Honor.
And also, you could choose to have a trial by a judge instead of a jury. And in such case, the judge cannot find you guilty unless the Commonwealth convinces the judge that you are guilty of the charge beyond a reasonable doubt. Do you understand your right to a judge trial?
Yes, Your Honor.
Do you understand that by waiving your right to a jury trial, the judge will be me? I will be deciding whether the Commonwealth has proven the charges. Do you understand that?
Yes, Your Honor.
Okay. And do you understand that by waiving or giving up your right to a trial by a jury, that I just already told you that. So do you generally understand the difference between a judge trial and a jury trial?
I do.
Okay. And do you have any questions at all about the difference between those two types of trial?
I do not.
Now, I'll just hand you this. And I'm showing you a form called the Defendant's Waiver of Jury Trial and Consent to Trial by a Judge. Did you read that form?
I did.
Did you discuss it with counsel or the attorneys?
I did.
And did you sign that form?
I did sign it.
And do you understand that the form says in writing what you and I have been talking about thus far about giving up your constitutional right to a trial by a jury?
Yes.
Okay, did you sign that form voluntarily?
Yes, I did.
And by signing the form, are you saying in writing that you know about and understand your right to a jury trial, which is explained on the form, and that you voluntarily give up that right?
Yes.
And do you now willingly and voluntarily waive your right to have a jury decide your case instead to choose? You think that I have never done this before. Maybe I'm the one that's nervous. Let me start over again. Do you now willingly and voluntarily waive your right to have a jury decide your case and instead choose to have a judge, that being me, decide if you're guilty or not?
Yes.
Okay. And do you understand that your waiver of your right to have a jury decide your case is final, and you cannot change your mind and ever ask for a jury trial again in this matter? Do you understand that?
Yes.
Has anyone threatened you or forced you in any way to waive your right to a jury trial?
No.
Has anyone promised you anything in return for your decision to waive your right to have a jury decide the case?
No.
Have you had enough time to fully discuss your right to a jury trial and the difference between a jury trial and a judge trial with your attorneys?
Yes.
Do you feel as though your attorneys have acted in your best interest and that they have fully and adequately explained your right to a jury trial and the difference between the two types of trials?
Yes, Your Honor.
Have you been confused by anything I've said thus far during this colloquy?
No.
So as I understand it, then you're waiving your right to have a jury decide your case, and you're choosing to have me, a judge, decide whether or not you're guilty because you want to and because you believe it's in your best interest to do so. Is that correct?
Yes, Your Honor.
All right. And the defense, any additional questions I should pose? Commonwealth?
No, thank you.
None? Okay. All right. Does the defense or the Commonwealth know of any reason I should not accept the waiver?
No.
Okay. All right. You may step down. Thank you very much.
Thank you.
Now, people watching this, first of all, this is something very rare.
Right.
You know, we see more often where a defendant will be quizzed about their right to represent themselves, right?
Or remain silent.
Or remain silent, and it'll be very much similar. This went even further, but to find out and make sure it's knowing and voluntary and intelligently made, and you're not drugged up and nobody's been leaning on you and all those things, because it's such an important constitutional right. We just don't see people, you know, give up jury trial right very often. And so to see this colloquy, very interesting. It just
Right.
doesn't happen very often. And
As we
that's why it sounds
discussed in a test that you passed so well
That's
the
right.
other day.
It was
There
close.
are, right, there are 4 things that a defendant is in total control of in a trial. And unlike, what witnesses to call or strategy, that it belongs to the lawyer. But for the defendant, it's whether or not you're going to represent yourself or not, right? That's one of the ones that's forgotten. Whether you're going to plead guilty or not, that's your right. Whether or not you're going to have a jury trial or not, and
whether to testify.
whether to testify or
And so
not.
that's still an unknown in this case. I don't know. I don't know. Let's talk now about some of the differences that we've experienced, bench versus jury trial, and let's talk about it in the context of that one issue. Are you, all things being equal, I know, unfair question, all things being equal, are you more or less likely to have your client testify if it's a bench trial instead of a jury trial?
Interesting question. That one I wasn't prepared for. All things being
Pop
equal,
quiz.
yes. If there is a benefit for this reason, as I've said in the past over and over again, trying to educate people, when you have a jury and you have done everything right, and then your client gets on the stand, and then it can't have gone worse. Doug Weinstein had a client like that.
What's his name? Casotis? Yeah,
Casotis, right? Did a
God.
great job, and then the client got on the stand, and it was all over within 3 minutes.
The whole thing.
Yeah, and also, I think that a judge is could be likely to forgive like one mistake because it's not going to oh my God, but a jury is not. So.
Yeah, it's. I know it's an unfair question, which, as you know, those are my specialty.
I know they are, but those are things to consider. Absolutely.
Yes, no doubt, and it's also going to be judge centric, because I don't think Bradel and Coakley get to this decision. Certainly not if it's McCarthy Naaman, but even if it's somebody that seems kind of neutral-ish, I just think this guy seems very fair. I'd put him on the very fair side of middle.
Right.
Just my
Me
gut.
too. Right. My gut is the first time he was on with the case, I was a little tougher. I was like, just make a decision. I mean, you're on the case, judge. You're the judge, But he was feeling the politics of the judges, the judge thing as opposed to the else. Right.
Yes,
right.
He was in a bad spot.
But if you recall, when Tim Bradel came out of that first hearing that he had, you were there, if I believe, and all.
Yeah. This is the only one I've missed, actually. Yeah.
Well, it was the one you missed. Okay, but Bradel mentioned we want Judge Karp on this case. We want him on this case. Right, that was right away. All right. So obviously, his reputation, Judge Karp's reputation, and all preceded him as being fair. So
and the key, he's not McCarthy Naaman.
Right.
So when you come from somebody like that, anybody's going to feel like a breath of hopefully fresh and fair air. But I just think Karp is. I go along with these guys. I think it's a good call in general. If I were to ask myself that same question, I think I would lean toward a jury more often than a bench, and just because I think because you're performing, telling a story to more people that might be more manipulative. Sensitive to your manipulation, because that's what you're going to do when you're telling your story for whomever your client might be. I think you got a better shot at that manipulation, just in general.
It's very interesting because I've only seen people waiving the jury when there's been some comment by a judge in chambers to both counsel being there, that would kind of indicate where the judge is heading. All right. And we're going to, in the future, have a case out of New York where somebody went through 4 trials, 2 reversals, finally was judged by a bench trial and was acquitted. So we can discuss that. I, as a prosecutor, had a case where there was a killing of a stabbing in the back of a doctor, father, and I identified with the family in the sense of it was an old Italian family. all right, and the father was a doctor, and that they kept the daughter who was schizophrenic in a closet, and one day she got out and she stabbed the father, and she was found not guilty by reason of sanity and sent way away because the judge had clearly, and even all of us involved in the trial, prosecutor not, clearly believed that she was insane, and certainly that would be an appropriate finding. And there was a waiver by the defense there, and that's exactly what the judge found, because it was such a horrible story on both ends, both the killing, but also just having your daughter who's, you know, her whole life living in a closet, right?
Yeah, and then so that's so emotional. A jury, you know, who knows where they would run with that.
Right.
What now? I do probably most of what I'm doing are bench trials, and here's the exception to my statement I made that I'd rather have a jury. If the case is complex, if it's a business litigation case, if it's a governmental entity case where you don't have things people can relate to, you don't have fights, you don't have you know, in this case, you know, an altercation where guns were used and somebody injured. If you don't have those things that this will sound horrible, but that regular people can grasp, you know, that they're a little too cerebral, a little too esoteric, or there's a lot of papers, I will rather have a judge. And quite a bit of the stuff I do now against government entities, I will do the judge because of that. Because the jury is like glazed over by the time you get halfway into your case, if not sooner.
No, it's interesting. You're absolutely right. But you're always still worried, no matter what. You're always still worried.
Oh, of course. That's my 8-second rule. The 8 seconds is the time when you sit down and you've done all you can do, closing argument, summation, whatever it may be, and the dread that sets in.
That's right.
Nobody knows how this is going to go, but you have 8 seconds of relative calm. Yeah.
If that, really, if that, Michael.
Well, you probably have less. You're a little more hyper. Maybe you get 6 seconds, but yeah, it's short-lived. We'll put it that way. And no matter how you did, you immediately start thinking, I could have done.
What could I do? I could have done this. Right, right,
maybe
exactly.
Maybe they liked this. Maybe they hated that.
Right. Exactly. Absolutely right.
So let's see. So it's going to be beginning on Monday, 9 a.m. And you know, barring, and the judge kind of made it sound like, well, you know, we shoot for 9 o'clock, but he almost blamed court personnel for not being ready, other practical matters. I don't know, but at 9-ish, they're going to get in there. Let me get your take on this. And we don't know how this judge does this, but sometimes with a bench trial, you don't do even an opening statement per se, or a closing argument per se. Sometimes the court, I don't think it'll happen here because we have somebody who's facing criminal charges and she's on probation. Well, she's on bail release.
Right.
So you're not going to want to leave her hanging. You know, his decision, I think, will come. Maybe he'll say, I need an hour after all the evidence is in, but I expect it'll be quick.
I don't think it'll be quick. It certainly, it may be overnight.
Yeah, again, it'll depend on when they finish.
Because he'll have a written opinion. I think he'll have a written opinion that he reads. Sometimes they're writing that as they go along. Sometimes it's depending on the evidence. I don't know how this judge operates. Obviously, somebody knows. But in the meantime, before we ask the next question, I did forget to say something. Please hit the subscribe, like, share, notify, and after this ends, hype, subscribe, like, share, notify, and hype for Justice Served TV. That gets us into the algorithm. I don't want to plead, but I'm pleading.
Just downright beg. Come on. And so that's another difference that people will see as this plays out. Remember, for those who watched Bev Canone, that was a bench trial for, and I never remember the names, but it was a woman accused of killing her husband, and it was the woman accused of killing the husband, right?
Right.
And he had a heart attack. He had a big heart issue, and he had a heart attack, and the medical experts were saying it was a heart attack.
Right.
And so
the question is whether she caused the heart attack, and therefore,
that's a tough one.
Ridiculous trial.
Yeah, unless you're causing a heart attack with fentanyl or something like that. But Judge Bev, bucking the odds and public perception, came back with the acquittal that most people thought was appropriate.
Right.
And we didn't really watch a lot of that. We had somebody was there watching it.
Yes. It was, and she hasn't been in the chat recently. I can't remember her name. She was a local and was very interested because Bev was going to be sitting on the Karen Reed trial. So I hope she's okay because we haven't seen her a while in the chat.
Yeah, you're right. And so it was, that kind of contrast was interesting to people, but we didn't really get to expose it as we might have. But again, that was a case where, as I recall, there weren't summations. Maybe there were, and they were very brief, and then she asked for something in writing. The judge can do anything the judge wants. I think this judge will want an oral introduction from both sides.
I think it's on oral. He may ask writing in the sum up, on the basis of has the charges been proven, and we don't know. We simply don't know. It'd be great if we had somebody local who knows him who could give us that inside information. And again, we don't know how many bench trials he has had recently.
No, and that can be researched. But in terms of his process, I don't know, and I have to believe that
direct email to Tim Bradel would be helpful. Mr. Bradel, do you know what Judge Karp's procedures have been in the past regarding this?
And he may have advised the attorneys at this point what they're going to do. Certainly how they're going to begin. Because he shouldn't dump on them that morning. Okay, let's go. Let's have give me your written opening, and then give me the Cliff Notes version orally. No, I think he's going to want, and I would want.
I think he's going to want an opening too. Right.
I want an opening. It's going to be different. It's not going to be as pound the lectern emotional. It's going to be matter of facts, just the facts, ma'am. Here we go. Tim gets a little emotional anyway, especially if you start mentioning the McCarthy name and scenario. Then he gets a little vaporized. Of course, it was outrageous, and he had to watch it happen to his client.
And also with a judge trial, they can take witnesses out of turn too. By the way.
And the judge even mentioned that in this hearing, just to tell the attorneys, I'm very open to flexible scheduling. I understand that sometimes people aren't available. So if we do need to take people out of order, I have no problem with that. He, of course, doesn't know if the defense is going to put on a case or not. They've suggested that I think they are. And they've put even a supplemental witness list together. So they have the joint witness list, and then the defense added 5 names to that list, including
Katie, that's my role.
That's you.
From the
Maybe
North
you should
Andover
show up that day.
Police Department. Katie
Gerke.
Interesting. I guess it depends on whether they call a Justin, doesn't it?
Yep,
they may say, if I'm the prosecutor, I'm saying the only issue is whether they pointed the gun at Noonan, and I'm only calling Noonan. Boom.
Yeah.
If you really want to, I'm not sure the prosecutor knows how to do that, and I'm not sure that Noonan's not going to have some problems. We'll see.
Well, think about, I think cross-examination of Noonan is going to be key, because he obviously will definitely be taking the stand. But think of the Karen Reed case, what the prosecution did in round 2 versus round 1. They sanitized their whole case by taking out these colorful witnesses that muddied up the whole case, and they just made it Proctor. Other than Jen McCabe, we didn't have the whole family, and so the prosecution in the Kelsey Fitzsimmons case could do the same thing, and keep Justin off the stand. Let's just you're going to have the officers that were there that day. I'm sure of that. The 3 of the officers, Noonan obviously, but then the other 2 were there as well. I think you need them just to lay out the groundwork.
They didn't see the shootings.
No. But I think you're going to have to lay some foundation and if I'm the defense, I like that because it shows this weird show of force. You need 3 cops to go in there, and what are you going to wrestle with this woman and steal the baby away from her? I think that is, if I'm the defense, I'd like to showcase that to the judge, just to lay the groundwork from the beginning. These guys were all about.
Let me give you one other thing. Okay, we've all said we've looked at the pictures, because there's an issue of a door or not, or was it the door frame?
The door, yeah.
Now, if this were a real forensic case, the CSI team would remove the door if it was an issue, and there would only be a door frame left. Okay, I just throw that out. I don't know the answer to that.
I don't think that happened.
We're going to find out.
Yeah,
I don't think it did either, but I throw that out because we've all been assuming one way or the other.
And I think the pictures we saw, I'd have to double check, but I don't think a significant amount of time passed between the incident and the pictures. That's
the realtor
to get in there and do anything. There was some months. I don't know that they went to that degree. And if we know the Commonwealth, I'd be shocked. They're not big on investigating things.
That's what we sold out of the Karen Reed
Who needs
case.
it? Who needs that? And just the misidentification of that important part of the scene. This makes you, discredits anything else anybody says. Noonan.
All right. And also his Flexerol issue, I showed the Commonwealth's going to object and said that he was on it after, not before, blah, blah, blah. I can see where they're going to go. And then they're going to be asking Noonan the question, why were you the only one wearing gloves?
Yeah. And remember, of the different motions in limine and the different Rule 17 requests, the defense is getting Noonan's employment records.
Right.
Not Justin's, but employment records from both North Andover and from Lawrence. So there may be stuff in there about prior use of Flexerol or other meds. So they'll be ready for that. If there's a flat-ass denial, they may have the ammo, the receipts, as the kids say.
Are we ready? Are we ready for this if the prosecution dismisses this case on Monday on the basis that their main witness won't testify?
Wow.
All right, I just throw all these possibilities out.
Are we ready? Yeah. Oh, we're ready. Yeah, we're ready for that. I'm not sure. I don't know the percentage of that likeliness, but anything could happen.
Anything could happen.
Yeah. Yeah. Maybe he's unable to perform, and so they can't go forward. I don't know. I do not know.
We'll see on Monday, right?
Yep. So I'll send Tim a note just to see if he's been given any indication, and I'll share that with the folks when we. The plan now is to fire up before the trial, which is starting at 9.
Because you'll be there.
I'll be there. I'll be there with with my purse, my Wi-Fi router,
our portable Wi-Fi router,
so I can be in the little plaza there, right in front of the courthouse, and not rely on Starlink around the corner. Yeah, and we'll know how it's going to fire off. If there's going to be statements, is there not? Who the first witnesses might be? We're going to work on it.
And then you'll have a 6 o'clock show. You'll be announcing who's co-hosting with you. I hope that you've gotten on the horn to Judge Ashley.
I
do.
Was great. She is lined up now for Tuesday and Wednesday, and you might even be available Wednesday.
Yeah, Wednesday I could easily be available. Yeah.
So that might be quite the party. Monday's still open. I'll work on that. I may just take advantage of people there,
right?
That can join me. I'm going to throw the tent up in the park right across the street. Daylight will be pretty good up until 7.
That's
We'll have our little mobile setup there, and I can hopefully drag a couple of people over to join me.
And so, Justice Served TV, 6 o'clock Monday night, but 8:30 in the morning, we'll be firing up this channel. There'll be a link, and there'll probably be a thumbnail, right, by then.
I would hope so.
I would hope so.
I hope so.
Yes.
We'll get our crack staff on that. Yeah.
That's how we need you to subscribe, like, share, notify. And if you want to be a donor, a member, whatever, to Justice Served TV, Michael Bryant needs those jelly donuts because he doesn't have
we got Cash App, we got Venmo, we got. Hey, I've seen people use that Buy Me a Coffee, which I don't relate to because I don't drink coffee. Could we have Buy Me a Pastry? Is that a thing?
I don't think they have that one.
Buy me a burger, anything? Okay, maybe I'll set that up. All right then. Everybody have a great weekend, partner. Have a great weekend, and good luck with the federal work next week. I'm sure that you will kill it for your client.
I hope so. She deserves it.
All right then. Everybody have a great weekend. We will see you next week. This is Justice Served TV. Please try to do the right thing.
On the